Um, okay, let's start. Good morning, dear participants. Welcome to the event Environmental Law Across Cultures, organized by the legal portal INTE 360 and INTE PUCP. We are very grateful for your assistance today. We have the honor of having the participation of 5 of the 12 authors of the book, matter of the event, which are Kirk W, professor of American law at the University of Cologne, where he is also director of the Center for Environmental Law and is director of the International Master's Program in Environmental Science. He was Associate Professor of Law and Director of International Programs at Duquesne University School of Law in Pittsburgh and the United States. Marek Prityi, advisor to the Slovak Ministry of the Environment. Prior to that, he completed his doctoral research in the field of comparative environmental law and the University of Cologne in Germany. Melanie Nishende, environmental lawyer, member of the ICCFP at the Secretariat at the United Nations in Germany. Dennis A. Jale, partnered at BAOS LP in Nigeria, PhD candidate at the University of Cologne in Germany. His research interests include environmentally friendly business practice and ethical. Saskia Münster, research at the Chair of American Law, where she managed research projects for the Center for Environmental Law in the University of Cologne. His areas of interest include comparative environmental law and water law. Vanessa Johnson is a lecturer at Monash University. She practiced in Australia in both state and federal jurisdictions. George Ignacio Garcia Nelson is a partner at the in Santiago, Chile. Yuan Ji is a lecturer at University of Nanjing, China. Her areas of research include Chinese environmental law and comparative law between the China and European Union. Also, we have three commenters. Cesar Gamboa, director of the organization BAR Environmental Law and Natural Resources. Patricia Iturregui, Master in Environmental Law at University of London. She worked for 7 years at the British Embassy in Lima as climate security and energy advisor, and has been the first director of climate change and air quality in Peru. Manuel Ruiz, senior advisor and researcher from Peruvian Society of Environmental Law. He is lawyer from the book between 20 and 2016. He was the director of International of the SPDA. We tell you that the present event will be recorded and questions from the public will be made for the audio. We'll start with Dr. Kirk W. Go ahead, Doctor.
Okay, thank you. I want to leave most of the time for our hosts and for people in the audience who want to ask questions. So I'll just make a few comments here that Patricia Izraegui had mentioned before we even began today. First of all, thank you. It is her initiative and the other colleagues from Peru to host this event. We had a book launch scheduled for Earth Day here in Cologne, and the virus had a different idea, so that never happened. So this is the first time that all the authors are coming together, and we have the opportunity to talk with an audience about the book. Patricia made a comment before we went live today that when she studied comparative law in London, it was boring. And most often comparative law, I think, is only an academic, intellectual excursion. And for that reason, it might be boring, but to me, worse, it's irrelevant. Because it is just academic puzzles most often. And we try to do exactly the opposite with this book. So thank you, Hasmid, for the introduction. If you were listening to the authors who were introduced, they are a mixture of practitioners and academics who've become practitioners, and practitioners who've become academics. And those two things to us are absolutely essential for doing comparative law. We're not just comparing cultures, we're comparing practice with theory and theory with practice. In addition to that, comparative law too often takes a very boring position of comparing dead written law. It's not alive, it doesn't work with the people who live under that law. So our perspective was that comparative law comes alive if it's the stories told of how law affects the people who live under it. And that is never compared in the boring academic discipline of comparative law. So we took that perspective and we gave ourselves the responsibility that only people from their own culture, because only they know about that culture from those people's perspective, would write and talk about the culture in the book. So we have every continent represented in our book, which I'm very happy to be able to say. We represent practice, and we represent the people who are under the practice of law on those continents. And I think that's all I want to say about how it is we conceptualize the book. And now I'd very much like to hear the colleagues from Peru, where I have had the pleasure of visiting only twice, to the two universities that we're going to be hearing from today, and hope that this is not a one-time only event, but the beginning of a longer collaboration. Thank you very much.
Thank you, Doctor. Now we continue with Dr. Gamboa. Go ahead.
Okay, thank you so much. Please, I'm gonna share my screen because I put in order my comments. I don't know if you can see.
Yes.
Okay. Cool. Let me check. Okay, so I'm gonna turn off my camera too because my signal is terrible. Okay. So first of all, many thanks to Professor Janker for allowing us to comment this book. It's a real honor to participate in this webinar and pleasure to be here and to share this panel with my other co-panelists. Also, I want to thank Patricia for this initiative as well. So I just try to sum up some ideas about what I'm reading about this book. I think that in the first chapter, Professor Janker wants to highlight the importance of comparative interpretation, not only for environmental law, but also for humankind. Yeah? He says that, so there are many challenges to carry out, but it's pretty clear that it's part of evolutionary advantage of our species, as Professor Janker says. No? So he said that there are many reasons to compare environmental law or legislation, such as improving one's own law. But I think that I would like to raise that the reason of avoiding war is a very persuasive reason, yeah, since the integration of the law can create opportunities for a common understanding of different legal systems. It's a way to continue to develop a society peacefully as humankind. And I think this is the main reason that Professor Jenkins wants to raise in this chapter. In the second chapter, that I have the chance to read taxonomy of comparison. I like a lot that, and it was very interesting how the Professor Janker links the Octavio Paz writings to clarify the content of the comparative interpretation. Is a way to improve our understanding of law through the literature, how to link the literature and the study of law. And also using this ancient method of presenting facts, accessos of Autores, Professor Janker presents us a way to answer the relevance of comparative interpretation in law, responding many questions. And I think that the key question of at least for me, was the how, I understand that it's very boring to assess the different models of comparison, such as formalists, encyclopedists, functionalists, but it shows us that comparing is a way to enrich and understand how to interact with not only statutes, bodies, legal system and families, but also legal traditions, cultures that are part of and affect the legal bodies. So it seems to me that all these questions will be essential to improve the comparative interpretation. But one of the how, it has a current relevance, because how we compare environmental law, as Professor Janker said, we can run the risk of introducing a colonial justification to impose a unique, correct, or normal legal system, excluding others. So at least for me, in a certain way, there is still a struggle between positivist and just naturalist philosophical perspective in the comparative interpretation that Professor Janker showed us. And I think that a possible ideological leak in comparative interpretation will depend a lot on answering this question that the Professor Janker proposes. In the chapter 3, locating environmental law functions among a legislative, judicial, and implementation body. We don't have much time to present all our comments about that. And I think the author present the function of the state in environmental problems, how the different models handle them. And these models are influenced by three dichotomies, the public law and private law system, where we'll see the public trust doctrine and public interest. The common law and civil law families, where we'll see the institutional arrangement concerns and public environmental regulation approach in each of these legal families, and the role of administration in a presidential system and in the parliamentary state, where we'll see the specialized administrative bodies and their performance. So, because we don't have much time to comment and to present our thoughts about all this chapter, it was very interesting for me. I'm gonna raise some key points now. I think that my first comments about the public trust doctrines for enhancing accountability in decision-making concerning natural resources, Within Latin America will be que los recursos naturales son patrimonio de la nación, Que has been applied from natural resources planning process, concessions, legal systems, or even environmental impact assessment, So it's for me, I think that it's a critical issue for Latin American countries, As its definition has changed since the neoliberal reforms of the 90s, which proposed a laissez-faire model, and after changed again with the beginning of the progressive governments that proposed a greater control of natural resources, in the last 20 years. Also, the public trust doctrine was criticized by the rights of nature, or summa causae philosophical perspective, saying the nature has rights and not just the humankind, the people, or just the nations. A substantive criticism is that through the administrative authorization, the state lost control of natural resources or their economic benefits. One of the clearest criticisms has been that the private interests are hiding under the concept of public interest and its purpose of the common good. I mean, it's the idea of how private interests capture the state and define in each case what is the common good, especially when we're talking about mining concession, oil and gas blocks, overlapping on local communities or public lands, they don't pay a fair compensation, or they don't pay taxes or royalties. In the case of Peru, for example, and I think it's an emblematic case for whole Latin American countries, Peru has a laissez-faire model, no? With a weak planning system. If we compare with Brazil or Mexico, maybe it's a different, there are different cases, but we have a weak planning system, inadequate legal control of resources. But I think in the last 10 years, through the Constitutional Court decision and legal reform, the management of natural resources has improved a little bit, especially how to handle the royalties or improve the participation during the implementation of each extractive project. No? So there were some changes in the environmental legislation, I think so, at least in Peru. No? My second comment is about according to the city experience of using the private environmental obligation system, or TORT law, I think it's a tool that has been growing slowly in Peru. However, from the citizen's perspective, there is a lot of mistrust that the current and traditional judicial proceeding can solve environmental conflicts. No? And indeed, it's true that marginalized groups' interests are not represented in environmental legislation and regulatory oversight. No? So private causes of action are invaluable, as the author says, but the private environmental obligation system is not used because of the slowness of the judicial processes, which are very expensive. They can take a lot of time. In short, they are ineffective. No? So we can see that there are some cases, for example, Chevron in Ecuador, Occidental Petroleum in Peru and USA, but there are very few successful cases. No? My third comment is about the public environmental obligation system. No? It is a criticism about these systems in Latin American countries. It's about the number of specialist norms and bodies with environmental competence and functions continue to grow. No? Especially the private sector complain the increasing of norms that regulate environmental obligations, and they propose some changes in that. So these criticisms has two reasons. No? A formal reason, I think, try to simplify and improve the text of the regulations, the environmental legislation. No? But there is also a substantive reason. No? I think that private sector trying to propose to reduce the standards. So in Latin America region, we are living right now a race to the bottom of the atmosphere. No? There are a lot of expectations to reduce the environmental requirement, for example, to approve the environmental licenses, to facilitate economic activities in the COVID-19 crisis and to reactivate the economy. No? A fourth comment about this chapter is about the mutually supporting relationship between administrative regulatory system of the public law and the private litigation. No? We saw this collaborative relationship between the courts, the judicial courts, and the civil society through, for example, the amicus curiae judicial tool or the constitutional dialogue that civil society organization that has knowledge about that present these amicus curiae reports during the judicial cases. No? But recently, there is also an administrative collaboration between civil society and administrative authorities in environmental matters, presenting evidence on environmental contamination, bringing experts, and presenting their opinion on these cases. So I want to say that not everything is in a black-white situation in the relationship between the governments to promote investment aggressively in the last 2 decades, and local population that have the perception that administrative bodies haven't protected their environmental rights. No? Another comment is about that in Latin American countries, we have the tradition of a strong bureaucracy and the historically omnipresent role of the state, according to the authors. But in environmental matters, I think there is something recent. No? There have been institutional changes in the last 20 years. No? Specialized environmental administrative bodies, for example, in Peru and among other countries, have been created by social pressure and environmental social conflicts. No? For example, in Peru, specialized and autonomous institutions have been created to approve the environmental license and to reinforce the environmental obligations. So we can say that maybe in civil law family, there is an emphasis on the norm and the necessity for consistency of the statutes and regulations. Still, for different factors, there is also a concern for institutional arrangements too, no? In environmental issues. No? I think that we don't have much time to talk about China, but I would like to raise at least one comment. No? I think it's essential to assess the environmental law in China, no? From inside and outside perspective, no? As the author said, there is a lot of opportunities in China, no? The environmental regulation in China is recent. It's a good opportunity how China developed the ecological civilization concept. And we need to recognize that China society or China government, or the Chinese government has inclination to avoid environmental conflicts. So it's very important how China applies environmental legislation under the principle of the extraterritoriality. I mean, how China regulates public and private environmental obligations inside and outside China, no? Because China is a global economy. So we can say that China should not just apply one country to system policy, no? China has to apply many countries the best environmental law policy, no? Thinking, for example, for their overseas investment in Latin America, they are continue growing a lot and a lot. No? So finally, in this last slide, I want to raise the one topic that the author mentioned in the chapter about the environmental administrative permits, no, or licenses. They try to raise how the different instruments are related to the natural resources governance, how to improve them, how to fit together, no? Land use plan, the development plan, the permits, and the environmental license, no? So in this graphic, I would like to highlight some, in the framework of the natural resource governance in Latin America countries, at least, we could find some common characteristics that the authors raised too, no? One comment, no? There is a low participation or a lack of transparency in the first planning stage, no? The land use plans or development plans don't include the mechanism for a full and active participation, for example, or the disclosure of environmental information. So these gaps at least bring some consequence, like the lack of legitimacy and effectiveness of the administrative decisions, no? And my second comment about what the author raised in the permits, I think for me, the permits create rights and establish environmental obligations. No? They can change the territory and introduce different ways to manage natural resources. So if we have a weak planning process for natural resources, each permit, even each license, constitutes a mechanism for disposing and affecting the environment. No? And many times, the permit assumes the responsibility of ordering the territory in the area granted for oil and gas concession, mining concession, if the government wants to build dams or roads. No? So to conclude, the authors show us the trends in environmental law in different models of state organization, and I believe we should assess deeply into some difference between these models and check if these trends are met in some regions, for example, in Latin America, that Latin America countries has embraced civil law as a tradition, but has been changing and including maybe the common law perspective, no? For example, these concerns about institutional arrangement, no? So for me, this book was a huge opportunity to continue assessing and comparing environmental legislation in Latin American countries. And thanks again to Professor Janker for allowing us to read this research. I stop here and thanks for your patience.
Okay. Thank you.
Thanks, Doctor. We continue with Dr. Iturregui. Go ahead.
Well, I'm very honored to be here to comment this book. Actually, I found it very valuable and useful for everybody and every country in the world, I would say, because it has all the views we may have, almost all the views, and that's a very remarkable effort. So I just wanted to say that I was really impressed by the fact on how the cultural approaches, if we are conscious of these cultural approaches, then we must make explicit the criteria we are using to make comparisons. And as for the various trends of functionalism or translationism or immersion, I would say I prefer immersion because it's kind of more accurate, and I believe Professor Juncker did that, isn't it? So jumping from the US law and then to German, living in Germany, I think he has the full immersion on German culture, and of course without bearing in mind all the rest of legal cultures. I believe this is the right way to do it, and I was impressed with the phrase that a technical functional comparison without study of national customs, without study of cultural research, and without loving empathy, it's a study that is only words, letters, and numbers that are not superficial only, but they lead us to mistakes. So I found that phrase really important. So to see the things in a true light, where we are from a certain distance as strangers, and I was remembering my husband, you know, he is from a different culture, he's a professor, secondary teacher of mathematics, I'm an environmental lawyer, so it's difficult sometimes, but I try to put my views on his culture, on his professional approach, and now I understand why he's all the time saying, you must do this, you must do this, you must do this. So actually, I find this is not for comparative law, but for everything in life that will lead us to be more tolerant and more loving and more successful and more happy in life. Well, actually, the main point I was all the time saying to myself while reading the book was, in justice, we have a matter important which is related to timing. Justice in Latin America, in Peru, timing is awful. I mean, you begin a citizen suit and you never know when it's going to end, and you never know how corrupted the judge will be. So that's an issue that is important, and it's a comment I have. So actually, yes. The other thing is on policy. I was really struck by the phrase that policy might not only mean a randomly observed set of past practices, but an observed set of acts of discretion. Discretion by actors within the law, but not required to do so by the law. I think that's a very, very valuable idea to apply in the analysis we do on environmental policies. What are the offices actually doing that are not required to do so by the law, but they do it anyway? So that's very interesting. Well, actually, I do have a PowerPoint, but I don't want to put everything there. I just want to say that I was not pleased with the one before. The one before, just me, please. Well, I was also impressed by the before. Okay. So I was impressed also by the phrase that, or the idea that, no, the next one, please. The idea that the US has the most complicated legal structure ever devised, and I fully agree with it, because this constitutional dualism in the US, when we were negotiating the trade agreement, of course, the environment chapter within the trade agreement with the US, it looked really complicated, and I would have loved to have this book before I negotiated with this team the trade agreement with the US, Colombia, and Peru. But when I read about the Indian dam, hydropower dam that was refused by the government, I was making myself the same question. What has been the most significant project promoted by the government of Peru and thereafter abandoned for ecological reasons? And I think we may go back to 1991 when we had the Environmental Code of Peru adopted in 1990. The next one, please. And Pacayas Immediate Reserve was under threat because of Texas crude oil exploration process of licensing. The next one, please. So Pacayas Immediate is 2 million hectares in the Amazon of a wetland that it provides fish to most of the native communities and cities in the Amazon. And also it's the home of the pink dolphin. And the environmental code stated that oil activities were forbidden in natural protected areas, and Texas Crude wanted to, back in 1991, wanted to make exploration for oil. So it was the first time, I think, that the environmental code was applied, and it was successful. I was working in the Peruvian Society of Environmental Law along with Manolo Ruiz, who is after me now. And that was quite an experience. So yeah, I just wanted to mention that. The next one, please, is related to the conclusions of chapter 3, where you are saying that it's important to understand a state-federal structure. And I was asking myself, but we do have 14 unitarian republics in the Americas. So if we change to a federal state, would this improve the environmental performance of the 14 unitarian republics in the Americas? So it's just a question to reflect. And at the end, I want to say that definitely we do have now 149 states in the world that have constitutional environmental rights. And can you go back, please? Sorry. I was not in tune with my PowerPoint because I was thinking this PowerPoint could be used afterwards, you know, after the event. But I just want to say that in the case of Peru, we have very strong constitutional provisions. For example, the compliance suit mechanism. So citizens can submit compliance suit to the government, say the Ministry of Environment, because they are not complying or pursuing the environmental rights in a specific situation. We have 3 environmental rights since 1990, the access to environmental information, the participation in environmental decisions, and of course the access to environmental justice without any specific standing. We just have the right to do it on behalf of the public interest. So the compliance suit and habeas data that is granted in the Constitution is like a very, very good tool for the 3 environmental rights that I mentioned. So we have it in the Environmental Code that is now replaced by the Environmental Act. And now, of course, with the trade agreement with the US, we are also obliged to comply with these 3 environmental rights. And so 10 minutes it's like very little time, but I don't know what point am I now. I just want to say that I was very impressed that the Supreme Court in the US has 300 hearings on environment every year, and that Supreme Court on China already has also a section for environment, only for environment, and that China has since 2015 an environmental act as well. So things are moving very quickly, and for the next slide, please. Do we have a new ethos because of the pandemic, a post-pandemic new ethos? We must bear in mind that the structural causes of pandemics, namely deforestation, unsustainable intensive agriculture, etc., are exactly the same causes of biodiversity loss and climate change. So this book, in this new context, is still an opportunity for the persons that want to help those with insufficient earth, water, and air will never read this book. I think this is just the beginning of a new way of producing and practicing on environmental law. Many thanks.
Thank you, Doctor. Now we continue with Dr. Ruiz. Doctor?
Yeah. Good morning, good afternoon, and good dawn time for whoever is in Asia, probably. First of all, I want to thank the organizers for inviting me to this presentation. I want to congratulate Professor Juncker for this book and the authors of each of the chapters. I know how complicated it is to actually end up with a book of this caliber and quality. So I really appreciate the effort, and I concur with all of my previous colleagues' compliments to the book. So that's the first thing I wanted to say. The second thing I wanted to say is, and I have to be very frank here, I have not read the book completely nor in detail. What I have done is focused on part 4 of the document, of the publication. And I have gone through the different chapters rather rapidly, just to familiarize myself with some of the issues and elements which the book contains. So I want to be very transparent in that. But I do have, and I won't take too much time, because I would like to hear some of the reactions to some of the comments which have been verted. I do have some general comments which I hope help in the discussion. First of all, I think what this publication demonstrates is how environmental law has rapidly developed and evolved over the last maybe 25 years. The UNSET process in 1992 was certainly a milestone, and one can actually witness quite literally how environmental law as a maybe independent discipline has evolved and has structured over these 2.5 or maybe three decades. I would say that barring maybe IT law, right, or technology-related law and disciplines, environmental law is the most rapidly evolving discipline. And the comparative approach which has been taken by Professor Juncker and his authors of chapters very clearly demonstrates this situation. I mean, most developments have been undertaken over the past 3 decades, starting in the 1980s. And I find that particularly fascinating in terms of what different law systems have done over the years. If one looks at certain disciplines, they have taken you know, maybe hundreds of years to develop and to consolidate themselves. But environmental law is pushing forward in a way which we have probably not seen. One anecdote which is not necessarily related to the book, but which I would imagine is in the book in the early 1990s, in Peru in particular. Environmental lawyers were maybe 7 or 8, and Patricia won't let me lie about this. There were maybe 7 or 8 environmental lawyers in the early 90s. Maybe 5 of them were working at the Peruvian Society for Environmental Law. 25 years later, we have hundreds, literally, if not more, of practitioners and academics and researchers doing environmental law. And I would say this repeats itself in the different countries which are touched upon in the different chapters and the different issues addressed in this book. So I just wanted to highlight this because it's important to understand the rapid pace of development of this discipline. The other thing I found really interesting was this idea of the title, Across Cultures, right? I guess that the title was thought of in purpose, and you didn't use across countries, right, in terms of the comparative analysis, but rather across the more sort of fundamental legal structures, institutions, and yes, legal cultures which each country has in terms of developing their institutional structures, the different instruments which are highlighted in the book, etc. And I find the title is really quite appealing in terms of the more classic environmental law texts, which are slightly colder, so to speak, in the way they present what they want to present. So that, I think, kudos to you, Professor Juncker, in the way you've structured the actual title of the book. More specifically, in terms of the actual section, I wanted to comment on, and again, I don't have a presentation, and I don't want to go through each one of the author's subsections in part 4, but I want to maybe concentrate on a couple of issues which I found in a way are cross-cutting each of the different sections in this portion of the book. And the part 4 starts with a section on public participation and dispute resolution. And again, public participation, I guess, is one, if not the most important principle which came about from the UNTITLed process in 1992. We can maybe go further back to the Stockholm process of 72, where participation issues were already, in a way, becoming part of the international agenda, but certainly UNTITLed is the trigger point for public participation in environmental matters, at least in many of our countries. And that chapter or subsection in particular discusses public participation in the context of litigation. However, I want to just highlight that public participation, of course, is not only limited to litigation processes, but has also been a critical aspect in how environmental activism and how the creation of environmental rights, a wide range of environmental rights have come about. And there's also a reference in that subsection to the different forms of law, and I found it striking that you could actually do this division in terms of the countries analyzed, in terms of common law tradition, a more Latin Roman type tradition, and then a mixture of these traditions in the way public participation is treated in the context of litigation and dispute resolution. There's also a subsection on economic choices which are enabled by environmental law, and there's an interesting example there of how the Dutch people, our colleagues, are actually driving changes into renewable energies and alternative sources of electricity in particular. And of course, then again, there's this cross-cutting issue of how participation of citizens in national processes trigger and create pressure on countries to start developing these type of alternative approaches to the generation of energy at the national level. So again, participation, I also find it important in this particular context. Then there's an analysis of environmental impact assessment systems in 3 or 4 countries, in Chile, Nigeria, and the European Union, and I don't want to get into the details or the specifics, but of course, environmental management systems or procedures are not only an environmental management need by institutions who are competent, but they have also been enabled and facilitated once again through pressure from public participation processes, and to a greater or lesser extent, depending on the ways and the channel for public participation, these different environmental impact assessment systems have become more or less effective in each of these countries. Finally, just to conclude, I found the section on environmental crimes also very interesting, and the highlighting of how it is complicated to criminalize environmental offenses or crimes. This again has become a very rapid development in criminal law in different jurisdictions, and I think we will see continued progress or developments in this particular field of environmental law. So I just wanted to make those very general comments, and just once again congratulate Professor Juncker for this huge effort, and I find again the title and the way the chapters are presented in the book particularly appealing. So thank you.
Okay. Thank you very much. And Jasmine, you are the moderator.
Okay. Now the authors of the book tell us about the book for 3 minutes. If you want, Doctor, you can start. Dr. Juncker?
I think I would rather give the floor to the many authors that we have present and hear what they have to say, or take questions. What I have to say is in the book.
Okay, so we start with Dr. Münster.
Thank you very much, Jasmine. It's good because I actually almost have to leave, so it's good that I start. So first of all, I really would like to thank you, Patricia, Manuel, Cesar, for your comments, for the reviews, and for also organizing this event today. So I just wrote down a couple of questions. I will probably not pose all of them, but just as a comment to the timing you mentioned, Patricia, in Latin America, and that it kind of takes forever to obtain justice. I just wanted to comment on that it's probably not only the case in Latin America, but also in Germany. So really can take up to years in order to obtain justice. And then I would like to ask you, because I thought it was a really interesting idea or question you had regarding the federal state. If you think, Patricia, Manuel, Cesar, that it would improve the environmental performance if you would have like a whole state of American countries just as a federation.
Okay, thank you, Doctor. We continue with Dr. Johnson.
Thanks, and thank you very much for your interesting and insightful comments about the book. I think the challenge for me from an Australian perspective when I was trying to create that chapter about resolution of environmental disputes is that in some ways Australia is both ahead of the curve and also behind in the way that it approaches those issues. We have diverse specialised tribunals that sometimes, as the comments have come in before me, make it more difficult to resolve disputes in a timely manner, as well as making it a bit quicker to resolve disputes. So they're beneficial and they're also a disadvantage to the way that we have to deal with that process, particularly because disputes can be so specialised. So my comment to add in there is that it's also echoed in Australia and also in that resolution process that courts and tribunals find it very difficult to deal with these matters quickly and effectively despite their expertise. Thanks.
Thanks, Doctor. We continue with Dr. Prityi.
Okay, hello everyone. So first of all, let me thank you for the possibility to participate in this session. So I have just made few notes when I listened to your comments and presentations. Thank you very much for that. Well, the first point to the boredom and comparative law. I'm also, like Patricia said, a fan of cultural immersion. I believe that to understand the broader cultural, social, political context of a country is necessary. And it also makes the process of comparing the different laws more interesting. So also when you mentioned that in Peru there are 60 cultures, did I notice it correctly, approximately? I can imagine that it's very difficult to draft a legislation that would cover all the different needs and all the of various parts of the population. And for this reason, I would like to stress the point that I believe Professor Juncker would probably agree that we tried to emphasize the role of citizen as actor in comparative law, to look at the laws and their implementation in practice from the perspective of citizens. And and in this regard, I would also like to emphasize the value of public participation in the context of legislative processes, which can enable, probably it's not a solution for every problem, but it at least enables to address points relevant from the perspective of various groups, including ideally also marginalized people. And to the point made by Cesar about the omnipresent role of the state on the paper, but in practice, the laissez-faire approach run by the private companies. When I heard these comments, it resembled to me a lot to the situation of Slovakia, perhaps in the 1990s, when the communist regime fell. And after that, there was a privatization, the neoliberal approaches. On the one hand, they served us well, but on the other hand, we also had to gradually begin to understand what really, what public interest really means. It was really hard to differentiate in practice sometimes between private and public interest. So that's also one of the aspects that are relevant from the cultural perspective, that it is also a process. So these were some of the points that I wanted to share.
Thanks, Doctor. We continue with Yuanji.
Can you hear me?
Yes.
So first of all, I will respond to the questions. I have participated in some programs of local legislation of the provincial levels in China for the past 3 years. So in my experiences, first of all, because I have learned the German law and American law in Cologne University by Professor Juncker. So in the program, in the legislation project, my duty is always to read and translate the German law or American law into Chinese, and to give them to give the local legislators in the provincial levels some ideas. Sometimes I think it's good ideas, and like the legislation background, the legislation goal, and the legislation characteristics. And right now I'm writing the evaluation about the German, wie heißt das? Verkehr, how to say that? Verkehr, das Verkehr in the Germany law.
Traffic.
Yeah, traffic. Yeah, how to control the traffic emission in the German law. So I will translate it into Chinese and give their background and some informations. But for me, I think right now there are some problems in the local legislations. First of all, during the legislation process, the local government sometimes didn't want to assume much state duties. So the state duties to control and monitor the issues like the traffic emissions, like the solid waste. They want to share the duties between many sectors. So this is a problem. So how to balance the duties between the sectors, the administrative sectors, is one of the problems. So I said this is the power issues in the legislation process. And the second problem is there are always a question between the technology and the legislation. So in these two sectors, the legislators couldn't understand the scientific reasons, and the scientific persons don't understand what the legislators said. So right now the legislation, this problem lead to the quality of the local legislation. So I would say, what is my third problem I have solved? Oh, forget, sorry. Forget, okay, two questions I have found, right. And I respond to the CSAS problem. In China, the environmental politics is the first place. So what the chairman, what's like the Xi Jinping chairman Xi Jinping said in some issues, it will be very, very important for academic people, for legislators, for local legislators. So right now the ecosystems protection, the environmental protection is the first important issue in China. So as an academic person, as a researcher, I am very confident for the environmental law in China. It is not only about the quantity of the environmental actors, but also it's about it's due to the quality, due to the usage of the applicability of the environmental qualities. So in the China's judicial systems, the hearing, every hearings will be like right now, will be published to the will be online published, and so it's for the publication, for the public to give comments. So and the result is also very, very strict. Okay, I have thought about my third questions. My third questions I have found in China. The third question is between the state, between the government and the enterprises. Yeah, according to the China's constitution, it is the state's duty to protect the environment and protect the natural resources. And but in the judicial systems, it is, but according to the general environmental laws principle, we have the polluter pays principle, you know. Yeah. So in the court, in the judicial systems, sometimes it is not very clear if the state or if the local government should take the duty to pay for the damage, or the enterprises to pay for the damage. If the enterprises have enough ability and enough money to pay for the damage, and the local government, of course, didn't have enough money for the ecosystem's recovery. So right now, it's very a big questions to balance there, to balance the local government and the enterprises, companies. So this is what I mean in China's environmental laws problem, practical problem, and yeah. Okay, it's finished.
Thanks, Doctor. We continue with Dennis A. Gallet. Dr. Dennis A. Gallet.
Yes, thank you very much, Jasmine. Thank you, our hosts, for this wonderful opportunity. Thank you, Professor Yonka, for also giving me the platform to be part of the project of authoring the book. The brief time I've listened to everyone that have been speaking, I've learned some new things. Learned about what's happening in so much about China just now. I've learned so much about the system in Latin America also. And my friend Marek, reading his own contribution about environmental impact assessments in Central Europe, the Slovak and Czech, also broadened my view and my understanding. I try to create a kind of horizontal comparison of the system that they have in Central Europe with what we have in Nigeria, and also look at what is applicable in Chile and most of the Latin American countries. It helped me to understand that one fundamental problem we have in African countries, especially Anglophone African countries, the non-democratization of environmental management. So we have the laws, we have the environmental laws there. However, the decision-making process that leads to concretizing these environmental laws is not there. As I listened to Dr. Patricia, in my mind, I was thinking that if I'm going to advise politicians in African countries, especially Nigeria, I'm going to tell them that if you're a legislator, you should have a comparationist. I think I had that word for the first time from Professor Yonka. You should have a comparationist as an aid. Because situation where you just look at, okay, there is this environmental law in Uganda. Let's pick it up and let's see how the system is there, and just let's make exactly the same law in Nigeria or in Ghana. You discover that you make that law and it creates more problem for the system, you know. So we have a situation like in Nigeria now where we were colonized by the English, we're former slaves of Britain, and then we are practicing the presidential system under America. And you look at the system in America, it's complicated. Every state has its own law. And then we come down to Nigeria. You, as a private citizen, cannot approach the court to bring up a matter that affects your environment as to the application or the strict application of the environmental impact assessment principle. And you have to depend on the state, the apparatus of the state, to approach the court where the system is not adhered to. So why do we have the law? It shows that the essence of the environmental impact assessment principle itself is to democratize the decision-making process. If it's not democratized, if the people are not part of the flow, if it's just there that they should be part of it, but they are not even aware of why they should be part of it, then the essence of the law is totally flawed. So I have learned so much from what we have in different jurisdictions, different cultures. You can imagine Nigeria with about 250 languages. And every state has its own way of how they treat the environment. And recently now they want to federalize the water costs. And lawyers are saying, no, the states should have control over the water costs. So that's because if there is flood, the people there, they are going to be more affected. The people in the Federal Capital Territory, there is no river there. So if lawyers that know much about this won't speak up, the people don't really mind. What matters to an average person in developing countries, let me feed myself, have accommodation, have shelter, wake up in the morning, go to work and come back. I've practiced as a lawyer. I'm into academic now. I'm passing through a very wonderful induction process under Professor Yonka into academic life. And it has helped me to understand how do we think through the process of making environmental law to be not just about what is in the book, but practically applicable, democratize in the process of making it, and ensure that it means well for people that are going to be impacted by decisions made in the process of applying environmental law. This book has brought us as lawyers and as legal experts closer to the thoughts of the people. My friend, an assistant professor in India, saw the book. He didn't know I'm one of the authors. I said, Dennis, I need to get this book. And he just started lecturing in India. And I said, check chapter 9. And he saw it. So, wow. Because the experience he's having in India is quite different. In Nigerian, based in Czech Republic, schooled in Charles University with me. And he's trying to understand, Dennis, what I'm seeing in India, the judicial system for environmental law is so interesting compared to what we see in Czech Republic, compared to what we have in Nigeria. So you see, he was a practicing lawyer, now an academic. He has a side of 3 different cultures, and this book is going to help him to broaden his view, broaden his understanding, his reasoning of how other cultures also apply the thought process of implementing, making and implementing environmental law in different cultures. I don't have any question to ask. If there's any question to ask me, I'll be very interested in answering the questions and responding to it. It's been a wonderful time with everyone. Thank you very much. I feel highly honored. Thank you.
Thank you, Doctor. Finally, we continue with Dr. Melanie Inglishende.
Hello, everyone. At the outset, I'm not a doctor yet, so just Miss Mrinalini Shinde is fine for now, and but I hope to be eventually. So primarily, thank you for organizing this call today, and it has been truly wonderful to hear your comments about our writing and about this project, because I mean, it's such an honor, the fact that experiences that we had in our domestic jurisdictions are not only read by lawyers and academics in other countries, but also we find new connections between our work. And that was one of the goals of this book, and I'm very glad to be part of this panel today. So continuing from what Dennis discussed about public participation and how environmental law in reality impacts the lives of the people who are at the very ground level and at the receiving end of environmental impacts. As a co-author of the book, the chapter on public participation with our colleague from Ethiopia, Segai, we looked into how the public can access the judicial system on their own without depending on the enforcement actions by the state, and also how this provision also exists in the United States as well. So I think the process of writing this chapter, it made me really think about how, when we think of a representation or participation of the public in our lawmaking, we usually think of voting and voting for politicians who will write our laws, legislators. When in reality, often we don't pay as much attention to how the ruling class and the ruled class perceive and are affected by environmental law differently, irrespective of how the democratic voting process works. So to take the process of environmental decision-making to the public is truly, I think, a unique aspect of public participation that we see very prominently in environmental law. And our colleague Marek is the expert on how public participation works in reality in decision making. But for me, the public interest litigation mechanism that exists within India has been, and in my experience, arguing for clients in public interest litigation in India, my main takeaway was essentially this, that the ability for the people to stop depending on lawyers, to stop depending on a very complex legal system to have their environmental rights enforced, is something very precious and something that needs to be protected. And I mean, if this trend continues, which I feel it will, given that we're seeing unprecedented levels of public protests, mobilization of youth, children on these on issues of conservation and carbon emissions over the past two or 3 years. I feel this trend is definitely encouraging as we go forward. In addition, before I conclude, I just wanted to add a comment to what Dr. Patricia mentioned at the very beginning, that Peru has so many cultures already, and the fact that you have to create environmental laws or laws generally, a legal system that reflects so many cultures. I really identify with this question as an Indian lawyer, given the number of regions and indigenous legal systems and traditional legal systems that we had before the common law system was introduced. So in that sense, Latin America and several nations in previously colonized Asia and Africa share this in common, this ability to find synergies between our traditional legal systems and modern, I wouldn't even say modern, but subsequent legal systems that were artificially introduced to those people. And in that sense, I think more comparative work between Latin America, Africa, and Asia is very exciting to me going forward, because often for comparative law, you see common law countries comparing themselves with each other. And I have been part of and guilty of this single-minded comparison in the past as well. But this book was truly a revelation in that sense, how we identify different contexts and similarities given our environmental problems and our legal systems. So with that in mind, I would also like to congratulate the countries in Latin America for very successfully adopting the ESCAZU agreement in 2018 on the regional agreement on access to information, public participation and justice in environmental matters in Latin America and the Caribbean. And Peru is also a signatory to this agreement. So it is truly a wonderful exemplary piece of international cooperation on ensuring that public participation in environmental decision-making and rights, especially rights to information, is protected. And I think I really applaud this attempt by the countries in Latin America to do this, and I hope more countries can follow. So that's all from me for now.
Thank you. If someone wants to ask, can raise your hand to ask the question or write it in the chat. We have two questions. Okay, Alexandra Sierra asks, I would like to know more about China and if the environmental regulation in Hong Kong is different since it has a special or political status. Who wants to respond to the question?
I think we have one expert. Ye, would you like to address that, please?
Dr. Juncker, you can ask. You can answer the question.
Okay. Oh, sorry.
No, there you go.
I didn't quite understand the questions. What were the questions?
The question was, does Hong Kong have a separate environmental system from the People's Republic of China?
Yeah, I think it's separated from the mainland China. They have their own legislation systems and judicial court systems. So I'm not quite clear about how do they do their work in Hong Kong.
Okay, thanks, Dr. Jane Zhuang. We have other question. It's for Karen Stephanie Ticona. In certain parts of Peru, especially on the south side, there is respect for the environment. The inhabitants of certain communities consider that the earth is alive. Payments are made here to the Pachamama to top for all that it offers us. That is, they have an incredible consideration for the nature or the so-called Mother Earth. For this reason, there are social conflicts between residents of large mining companies to defend their natural resources. They don't allow the exploitation because they damage the environment. It is very interesting topic. Maybe we can comment this.
I think I introduced this thought about these criticisms about the summa causa and then the nature of rights that the Constitution of Bolivia and Ecuador 10 years ago includes as a clause, yeah. And I try to respond to the question about there is a contradiction in the environmental legislation at the constitutional level, especially in these two constitutions, because I consider it's a rhetorical constitutional clause saying that we are going to recognize the nature of rights, that the nation has rights, but at the same time, in the same constitution, we recognize the public trust doctrine or the idea that the natural resources are considered as patrimony of the nation. So it's at the same time, the nature is an object and a subject, no? A subject of rights in a rhetorical way, and an object that the in an anthropocentric view we can obtain benefits from the nature. So I recognize that we have different cultures in Peru and in the Latin America countries, and in the Andes Amazon, we have indigenous people, communities that has a strong relationship with the nature, with the lands. The culture continue growing, not thinking about the people, but also the community based on this space related to nature and society. But I think that our law, an environmental law, at least in the last 30 years, continue the same path based on the same principle from anthropocentric perspective. And I don't see any changes of that, no? Even the Escazú agreement, no? But it's very similar to the European agreement, the Aarhus Convention, yeah? The fundamental values of the Escazú agreement is to continue expanding the environmental rights, related to the participation, to access to information, to access to justice, and even including in the Article 9, the environmental defenders as an obligation for the Latin America and Caribbean countries. But the common values are related to the traditional view of natural resources governance, and not from this critical perspective of how we understand the relationship between nature and people, the nature and the society. So this is the point that I want to raise, and I totally agree with what Miri and Ali said about the Escazú agreement. Unfortunately, in Peru, it's not a good example right now, because we are discussing right now if the Peruvian Congress will approve the Escazú agreement, and we are living in a conservative political reaction against the Peru can adopt the Escazú agreement, because they consider that this agreement affect the sovereignty of the state, of the Peruvian state right now. So it's a there is no fundamental for that. There is no argument for that. This is just in a political perspective that they consider in a especially the private sector consider that the expansion of the environmental rights isn't a threat if we want to continue growing in the traditional way that we did it in the last 30 years. Yeah, so we need to reduce or to delete the natural resources governance. They don't want to include, for example, more participation in the process of making decisions in the environmental issue, for example. They don't want more transparency. Even we're living the effects of the Lavallato scandal corruption in Latin America. They don't want to include more transparency in how the government making decisions of the natural resources. So it's we are living in a contradiction, but we have a hope that other countries, Argentina, for example, Mexico, they start the discussion, and in the Congress of Mexico, that they could approve a Escazú agreement, and I don't know, in the coming months, or they enter in vigor this agreement.
We thank our speakers and attendants. We invite you to follow us on our social networks, the Facebook of Use et Veritas for more information and diverse legal content. We thank you very much and see you at an upcoming event. Thank you.
Okay, thank you all.
Thank you. Thank you.
Thank you very much.
Thank you, everybody.
Thank you.
Thank you.
Thank
See
you.
you in the future.